and that should be in a final judgment, and that none of this $340,000 in equity in the marital residence he's entitled to. And then they have the temerity to file a response to a motion alleging in a public court file, implying that somehow my client, when getting massages to treat his spinal radiculopathy, his cervical spine radiculopathy from his years of firefighting, that somehow he's consorting with prostitutes. I find that argument and that strategy to be absolutely
Welcome to The Wall. In today's video, we're going to look at the case of a greedy ex-wife who not only earns over $160,000 a year, but also has more than $500,000 in assets. And what does she say? That the house is hers alone, and that she has no intention of sharing anything with her husband in the divorce. She literally wants the whole package, to keep everything and leave him with nothing, not even a lawyer. I'm not asking for anything more than you're like. It really helps push the content forward. Drop a comment with your experience and wisdom. We always pin the best one for the community. Subscribe, and without further introduction, let's get started.
In the virtual courtroom, we have both parties as well as their respective counsel. Mr. Burke on behalf of the plaintiff, Mr. Haslam on behalf of the defendant. We're here on the defendant's motion for attorney fees. Mr. Haslam, I have read the motion. Is there anything else you'd like to say at this time?
I do have a few things. I do have a few things to add, Your Honor, that I think are germane to this motion. Number one, when we take the plaintiff's own appraisal and subtract the latest, at least the latest figure we have been provided with, I think from April, with respect to the marital home that she claims is all hers and refuses to acknowledge that there was any marital equity built up over the marriage, purchased with about a $17,400 down payment 2.5 weeks before marriage. That's a $340,000 source of untapped equity. She also has, again, according to the figures we were provided that date from March, over $172,124 in a 403B contributory retirement plan, which gives her, not with exactitude, because we're not subtracting her, credit card debt and things like that, I suppose, but that isn't that large. We've got a plaintiff here with a net worth exceeding $500,000. When we look at the other side, the flip side of this coin, this was a case and is a case, Your Honor, essentially of, I would suggest, gender reversal. We have a husband who doesn't earn very much. Her earnings are about 2.6 times his, even at this point. He has almost $382,000 in student loan debt. And he had to purchase a replacement transportation, that Toyota, and so that is very heavily leveraged. From the time of being in medical school, pursuant to the agreement of the family, his credit cards are tapped out. He does not have the ability, Your Honor, to walk into a bank and say, give me a personal loan. I think, as this court knows, anybody can go buy a car. That's because the new car is the collateral for the loan. And if you don't make the payment on the loan, they repossess the car and sell it. He's borrowed in the interim $10,000 from his mother, who I believe is in her 80s, but he has tapped out here his ability to borrow. And I know that counsel has thrown around a number of speculative and unsupported assertions in their response by plaintiff to this motion. They say he doesn't pay for anything. Anything he earns is just free mad money. Absolutely not true. He pays for the family's health insurance. He pays for auto insurance. He buys groceries. He pays all of the expenses for the children's expensive travel soccer, including the registration, uniforms, equipment, pays for the tournaments, and pays for the travel to take them on these travel soccer expeditions. And I know from personal experience, having done that with 2 of my children, it is very expensive.
As you can see, here we're dealing with a very interesting case, where Mr. Brandt is asking the court to order his ex-wife, Mrs. Brandt, to pay his attorney's fees. Apparently, this is part of a divorce settlement where she refuses to give up a single cent because, surprise, She's the one making nearly twice as much. When it comes to 50-50, suddenly she's not a fan. Brothers. Mr. Brandt is drowning in debt, with student loans nearing $400,000 and no way to continue funding his legal defense. That's why he wants to invoke MCR 3.206(d)(2). Michigan court rules, a provision that allows the court to order the party with greater resources to pay part of the other's legal fees in cases where there's a disparity in income. It's a tool meant to prevent one side from showing up with a legal dream team and the other with whatever their mom could lend them. But let's continue.
They say his loans are going to be forgiven. Absolutely not true and absolutely speculative. I think this court knows the status of student loan forgiveness programs. My client is not involved in a student loan forgiveness programs. The only way these loans are going to be paid back is by him paying them. And that's the fact at this point. That's entirely speculative. They say he should go borrow against his 403B. He isn't vested sufficiently to the point where he can borrow against the nominal amount of money in there. If I recall correctly, I think that's somewhere in the range of about $30,000, but he simply can't tap that at this point. The plaintiff also makes some misleading assertions and doesn't include dates in terms of this alleged loan the plaintiff took against her 403B some years ago. Both of these parties apparently had some credit card debt they wanted to pay off. And since my client was still a medical student at the time, she borrowed some money against her 403B and they paid off those credit cards. But that was years ago. And his credit cards are back to being maxed out because of all the expenses that he has incurred. And I would be remiss if I didn't tell the court that part of the process with respect to his attending medical school was that he didn't just borrow, Your Honor, the money to pay the tuition and fees and direct costs. He took additional, I think they're called plus loans, to recontribute what his income would.
Let me stop you a moment, Mr. Haslam. I read all that, so we're just kind of rehashing what I already read. So,
well, Your Honor, I wanted to respond to some of the misrepresentations made by the plaintiff here, and I know there's a question, and I think plaintiff raises it rhetorically. Well, he was only asking for $15,000 before, now he's asking for more. Well, as you read in my supplement, Your Honor, we wasted almost an entire day at mediation with no response other than just flat nose to the plaintiff. We then find out that they have hired a very expensive valuation analyst, Michelle Gallagher, and paid $5,000. She claims the source of some of her expenditures are loans from her parents. We've seen no promissory notes. To the extent her litigation is being funded, when she makes between $150,000 and $160,000 a year being funded by third parties, I think that makes it more appropriate to give him an award of fees. Look, she's taken the position that as far as their children are concerned, and they're both still living together in the marital home, he can have parenting time as they agree when he's not working.
This woman is earning between $150,000 and $160,000 a year. She's probably a doctor or has some high-level profession, because that's a lot of money. On top of that, the house has already been fully appraised and it's valued at over $700,000. So she knows exactly how much everything is worth, but she doesn't want to split anything. She's dragging out the process on purpose. Why? Because the more time goes by, the more she can protect her assets before the division. I won't deny it. As a strategy, it's working out for her. The problem is that this poor guy doesn't have that luxury. That's why he filed a request for $15,000 in attorney's fees, using the MCR 3.206(d)(2) rule. In simple terms, he's asking her to pay so he can keep fighting against her. It sounds ironic, but without that help, he can't keep going. Later on, we'll take a look at how much he could get in a 50-50 split, and I'll tell you right now, there's a lot on the line.
And that should be in a final judgment, and that none of this $340,000 in equity in the marital residence he's entitled to. And then they have the temerity to file a response to a motion alleging in a public court file, implying that somehow my client when getting massages to treat his spinal radiculopathy, his cervical spine radiculopathy from his years of firefighting, that somehow he's consorting with prostitutes. I find that argument and that strategy to be absolutely, simply absolutely inappropriate. We're asking for the increased amount because unfortunately we can see the handwriting on the wall here. And with her $500,000 in assets to fund this, in addition to receiving additional money from her parents, my client being tapped out and his only source of funds being his 80-something-year-old mother, and that has come to an end. He is entitled to an award of fees and costs under MCR 3.602D to enable himself to hire an expert, pay his lawyer, and fund his defense of this action.
Mr. Burke.
Thank you, Your Honor. I don't want to regurgitate what is in my responses and briefs. I know that was probably a lot of reading for you, but I want to just note the timeline of defendant demanding $25,000 in attorney fees. He filed this motion immediately before mediation in an attempt to coerce a settlement. And Your Honor, Ms. Brandt did participate in mediation in good faith. We actually went over the time limit that we had originally scheduled for mediation. I pushed back appointments in that day to complete mediation. And quite simply, we weren't going to agree to defendant's demands. And what does he do after this? He increases it by $10,000 after mediation. And quite simply, this is nothing more than a money grab, Your Honor. The defendant makes $65,000. As referenced in my brief, that is an average household income in Michigan. And the only financial document before this court, when it's defendant's burden to prove this motion, is actually an exhibit that we submitted showing his attested monthly expenses, which are nominal. I've recently reviewed some financial statements provided by defendant showing that his student loan payments are about $50 a month from the withdrawals that I could see out of one account. I know that Mr. Haslam focused on the equity in the house. That's not relevant as to an ability to pay. And the reality is that Ms. Brandt still has a loan against her retirement account for the $14,000 credit card fees that she paid on defendant's behalf. I do want to just reference briefly excuse me here, Your Honor, the Smith v. Smith case that is referenced in our brief in support. Mr. Haslam is familiar with that case, and it comes from this circuit court and then affirmed on it by the Court of Appeal, showing that it is defendant's burden, not through blanket assertions in an affidavit, but providing actual financial documents to support the requested relief.
Stop it. Get some help.
I've got to say, the defendant's lawyer is pretty sharp. We're talking about a situation where this man could receive up to $340,000 just from the equity built up in the house. On top of that, he earns $65,000 a year. Not a fortune, but definitely not a miserable salary either. Meanwhile, his ex-wife has over $500,000 in assets, which clearly gives her room to drag this process out. And that's exactly what she's doing, using time as a strategic advantage. But her lawyer dropped a key line. If you're claiming to be broke, then show us the bills. Because if you can't prove your expenses, then you're just lying in court. And this is where the case Smith versus Smith comes in. It makes it very clear, words aren't enough. You have to present real evidence, receipts, bank statements. If you don't, your motion falls apart. That's why things are getting interesting now, because next up is the response from Mr. Brandt's attorney. And trust me, he didn't stay quiet.
The defendant has very minimum expenses, and his income is quite simply disposable income that he uses for his sole benefit. We ask that the court deny this motion. We think that he has the ability to pay, especially considering the fact that in less than a year, he's going to be making in excess of over $300,000. In addition to that, there are several loans available for resident physicians, recognizing that in this interim residency period, they don't make significant money compared to what they will make outside of their residency. He has funds available to him, and we ask that the court deny this motion.
Right.
Thank you, Your Honor. As the court no doubt is well aware, I am familiar with Smith versus Smith. It's my reported case in the Michigan Court of Appeals dealing with termination or modification of post-judgment spousal support based on cohabitation. That's a completely different context, and it really is inapposite to a request for attorney fees and costs to enable my client to defend this action. He doesn't have $5,000 to hire somebody like Michelle Gallagher in this situation. He's entitled to do that, and he's entitled not to be oppressed by the party with all the assets and all the money. Like I said, you take a look at that net worth, my client's a negative almost $400,000, and the equity in the home is certainly relevant. One can set up a home equity line of credit in about 48 hours to have access to those funds. And for counsel to sit here and say, I know about loans that are maybe available to resident physicians. Again, speculation, just like, oh, all his student loans are going to be forgiven, with absolutely no factual support. What we do have factual support for, Your Honor, is that the plaintiff here has an income that far surpasses my client. We have to look at this point in time. Number two, he's tapped out his available lines of credit. Number three, the plaintiff will continue in this litigation. She has engaged this expert. She says she's going to value his degree. We have to be able to do that as well. And we can't be victimized by the plaintiff's obvious plan here to put Ryan in a position where he can't pay his lawyers. His outstanding bill with me, I think, is almost $9,200 at this point, and to hire an expert. Now, when I asked for the itemized billings that the plaintiff had paid her lawyer, they claimed it was privileged and only sent me transfer documents showing money being transferred from their trust account, I believe, to their general account. But in any event, look, we have a huge disparity in income. We have a humongous disparity in assets. Will he likely make some money in the future? Probably, but we have to get through this case now. Our 1-year anniversary is coming up, I believe, in February, and he has to have funds available to him at this point to defend this action. We don't care if the court labels this temporary attorney fees or labels it an advance that would be determined later by the court as to whether it's attorney fees or an advance on his property settlement award, either one. But right now, he does not have the money to adequately defend himself in this act.
Solid defense from Mr. Brandt's attorney. We'll see later what the judge has to say, but for now, he made things clear. He responded that the accusations from the wife's lawyer are nothing but pure speculation, that he might earn more in the future, that he could get loans, that his debts might be forgiven. But as he himself said in court, decisions aren't made on maybes. They're made based on facts. And under the law, speculation is not valid legal evidence. And he did bring facts, that she earns twice as much, holds all the assets, receives financial help from her parents, and even hired a professional appraiser just to drag things out. It's clear her plan is to hold out financially until he can't keep up, a common tactic when you have the money to sustain it. That's exactly why he invoked MCR 3.206 D2, which allows the court to order the party with more resources to cover legal fees when there's a disparity in income. As his lawyer put it, we don't want charity, we want a fair fight. And in family law, the court is obligated to ensure that.
All right, thank you. Pursuant to MCR 3.206, based on the information that the court has at this point, the court finds that the plaintiff does have the ability to assist in attorney fees for the defendant, that the defendant does have some need, given the disparity of income and the litigious nature of this case, particularly with the hiring of an expert. So the court will grant $15,000 as an advance on any ultimate property settlement.
How soon is that to be tendered to my trust account, Your Honor?
14 days.
14 days. Thank you. I'll prepare an order.
Brothers, justice has been served. Mrs. Brandt will have to pay $15,000 to Mr. Brandt's attorney. Why? Because she's the one earning more. She holds the assets. She hired experts to stall the process, and yet still expected him to defend himself without a dime. And as the judge said, there's a proven income disparity and a demonstrated need. That triggers Rule MCR 3.206 D2, which allows the court to order one party to pay legal fees if those two factors are met. But the key here was the defense by Mr. Brandt's lawyer. He didn't come to whine. He came to prove his case. He brought numbers, compared incomes, documented the debt, and dismantled the other side's narrative with a clear argument. My client can't continue in this case unless the playing field is leveled. While her lawyer talked about possible loans and future income, he presented hard, verifiable facts. And in court, as established in Smith versus Smith, decisions aren't made based on speculation. They're based on evidence. That's why he won. Mrs. Brandt's face when she heard the ruling said it all. She took a deep breath because she realized the show was over. We've reached the end of the video, but before we go, the questions are for you. If she had $500,000 in assets, why did she want her ex to be left without a lawyer? What do you think of Mr. Brandt's lawyer's defense? If you enjoyed the video, make sure to give it a thumbs up, subscribe to the channel, and hit the notification bell. Your support means the world to us and keeps us motivated to keep creating more content. Stay tuned for the next exciting video from The Wall.